legal proceedings on the proceedings of the County Assembly of the 18th and the 26th of June 2025, it then cannot fall from the governor's mouth to come here before you this morning and assert that there were no proceedings. They have based substantive legal proceedings on the fact that there were proceedings. They have gotten certain orders from the High Court in Meru, which orders they seek to bring before you and urge you to declare the proceedings a nullity. I submit that they cannot. And for the completeness of the record, I submit that an estoppel arises against them approbating and reprobating in the manner in which they do. And an estoppel, for the purposes of my submission, is a legal principle which precludes a person from asserting something contrary to their previous action or statement. The contrary provision is that there were no proceedings. The previous action is that they took those proceedings to the High Court, persuaded the judge of the High Court that there were proceedings and obtained orders. They cannot do both. And for that reason, I urge you, I submit that that ground of the PO must fail. There is the issue that my good and learned friend, Mr. Theory, commenced with, and I wish to crystallize that issue as the threshold issue. The short and sharp answer to the threshold issue is that threshold, the determination of whether or not a motion surpasses the threshold required in law requires the consideration of testimony of evidence from both sides. And the consideration of evidence must of necessity, Mr. Speaker, include the testing of that evidence. There are witnesses that the governor has brought, and there are witnesses that the governor has brought and their testimony was referred to in support of this submission. We, as the advocates who are present for the County Assembly, wish to test that testimony. We do not believe that what has been stated in those statements is correct. Those facts, Mr. Speaker, are therefore contested. And if they are contested facts, they then cannot form the basis in law or otherwise for a preliminary issue. That must go on to full trial, and in the context of these proceedings, that means the hearing of the motion that has been brought. Mr. Speaker, one of the reasons that the governor gave for in support of the submission that the threshold has not been surpassed was the fact that the minutes in support of those, the Hansard, sorry, not the minutes, Mr. Speaker, in support of those two proceedings were not signed. Mr. Speaker, we note that one of the governor's witnesses is the clerk of the assembly, the County Assembly of Isiolo. Most unusual in the circumstances, because it is the clerk's responsibility to sign those Hansard proceedings. We look forward to the opportunity, Mr. Speaker, to test the testimony of the clerk and get the clerk's explanation. And we believe this House can only benefit from that explanation from the clerk, who is charged with the primary responsibility of certifying those minutes, as to his explanation as to why those minutes were not certified. The clerk is a witness. He has put in a witness statement or an affidavit, and we wish to test his testimony. Mr. Speaker, it is my submission that with the facts contested as they are, it is then difficult to use those facts to then make a determination on the preliminary issue. The next issue that I wish to submit on and emphasize is that the material that the governor wishes to rely on for his preliminary issue is the same material that the governor has brought forward or seeks to rely on as testimony in opposition to this motion. Mr. Speaker, members of the House, I wish to refer you now to Volume 2 of the Governor's response to the motion that is before you. And in Volume 2, there is the statement at page 24, and this statement runs all the way to page 32 of one Salad Buro Guracha. Salad Buro Guracha is the clerk of the County Assembly of Isiolo. As I have said, in a most unusual way, he is a witness for the governor. He makes certain averments in that affidavit, which we need to test. Those averments have been repeated by other witnesses, and it is those averments that have been relied on by my learned colleagues on the other side in support of their assertion that there is indeed a preliminary issue that requires consideration and needs to be determined as a preliminary issue. Mr. Speaker, I wish to cede the remainder of our time to my colleague, Mr. Mawira, but as I take my seat, Mr. Speaker, I wish to make the following suggestion. Mr. Speaker, it is apparent in a rather blatant manner that the issues that have been brought as preliminary issues before you are not preliminary issues, whereas they may be issues that are fit and proper for the determination of this House, but they are not fit and proper for determination as POs. My suggestion, Mr. Speaker, is that the PO be dismissed and that the governor has an opportunity then to ventilate those issues in his evidence in opposition to the motion, and that this House then makes a determination on those issues once it has had the benefit of hearing testimony from both sides, and both sides have had an opportunity to test that testimony. How much of that?
Honorable Speaker, my name is Mawira. I'll take the remaining time to buttress the submissions that have been made by my learned senior. Foremost, Honorable Speaker and members of this House, it is not contested that there is no order, there is no conservatory order stopping Senate from considering the impeachment motion that is before you. There is no order by court injuncting or enjoining this House not to proceed with the business of the day. What the governor challenges or impugns is the validity or otherwise of the impeachment motion that is before you. I submit, Honorable Speaker, that the question of validity of the impeachment motion is a question of interpretation and is reserved for the judicial arm or branch of government at the opportune time. As my learned senior, Nyamoji, has already submitted, we have authorities in the submission that we filed in response, and this Honorable House has given rulings in previous matters, including the previous ruling in the impeachment, in the matter of the impeachment of the governor of Kericho County, that legislative processes that are before Parliament, the moment this House or Parliament is seized with a resolution by a county assembly to remove the governor from office, this House becomes irreversibly seized of that impeachment motion, and no order of court can stop this Honorable House from conducting its business. More importantly, Honorable Speaker, that position has been adopted not only by this Senate or this Parliament, but by other parliaments world over. We have authority in the report of the Committee on the Proposed Removal from Office of the Governor of Embu County. that the Senate becomes irreversibly seized of the matter the moment the Speaker of the Senate receives a letter from the Speaker of the County Assembly communicating the resolution of the Assembly to remove the governor from office. The committee went ahead, Honorable Speaker, to quote similar positions adopted by parliaments in other jurisdictions, including Ghana, in the Supreme Court of the decision there, Honorable Speaker, Sri Lanka, and the United States. Honorable Speaker, the position that has been taken by this House in previous impeachment proceedings has been adopted by the highest court in the Republic. The Supreme Court, in the matter of the governor of the former governor of Embu County, Martin Wambora, and the Court of Appeal have agreed with this House, Honorable Speaker, that the judicial arm of the state cannot direct Parliament on what to do and not what to do. Therefore, it follows, Honorable Speaker, that at the opportune time when this Honorable House has conducted its proceedings, these proceedings will then fall before the judicial arm of the state. And at that time, the judicial arm of the state will have every opportunity to test the proceedings of this House for constitutional compliance. It is agreeable, it is common ground, Honorable Speaker, that the proper judge of compliance with the Constitution and the standing orders of this House and the statutes relating to the removal proceedings of a governor is the judiciary. The question or the point that is not agreeable by both sides is at what point can the courts stop an inchoate or an ongoing constitutional process that is before the legislative assemblies. The Supreme Court, Honorable Speaker, in the matter of Martin Wambora, had occasion to deliberate on this issue. And at pages 6 of our submissions, page 6 and 7, Honorable Speaker, you will find an exposition of what the Supreme Court said. The Supreme Court explicitly forbade, Honorable Speaker, courts from granting orders that stop ongoing proceedings that are before legislative assemblies. And to quote what the court said at page 6, in fact, it is at page 7, Honorable Speaker, no governmental agency should encumber another to stall the constitutional motions of the other. The best practices from the comparative lesson signal that the judicial organ must practice the greatest care in determining the merits of each case. So, the question that arises, therefore, Honorable Speaker, is while the governor impugns or challenges the validity of the impeachment motion, the validity of the court order that was given, which court order is a basis of the challenge that the governor has put up to the propriety of these proceedings, is also in question. The validity of that court order is in question because, Your Lordship, because, Honorable Speaker, the highest court in the Republic have affirmed what this House has stated on numerous occasions, that the judicial arm of the state, though it can intervene to stop or to check for constitutional compliance, that process before the Legislative Assembly should be left to run its full course, and at the opportune time, the judicial arm of the state can intervene to check the propriety of those proceedings. Therefore, Honorable Speaker, can a court, the High Court, and Honorable Speaker, Section 5 of the Judicature Act provides for the hierarchy of laws in our Republic. The Constitution is at the top. Honorable Speaker, the apex court in the Republic, as per our Constitution, is the Supreme Court. The Court of Appeal is next. The decisions of the Supreme Court as per Article 163(5) of the Constitution, Honorable Speaker, are binding on the High Court. The same goes for the decisions from the Court of Appeal. The question, therefore, is, can this Honorable House be stopped by a court that has disregarded binding precedent? Can this court be stopped by a court that itself is lacking in jurisdiction? Our response or our answer to that question, Honorable Speaker, is that you should proceed unhindered, undeterred, and render a decision or a determination on the impeachment motion on the merits upon hearing the witnesses that are to be called by the respective parties. The danger, Honorable Speaker, is if this Honorable House was to terminate the proceedings at this stage, then, Honorable Speaker, it would set a very dangerous precedent. And that dangerous precedent, Honorable Speaker, is that all that a governor would need to do is to move to court and obtain an order either quashing the impeachment proceedings before they even begin, or stopping this House from considering the impeachment motion before it is even seized with that impeachment motion. And therefore, Senate would have abdicated its role as a defender of devolution. Senate would have abdicated its oversight mechanism in the removal from office proceedings of county governors. And therefore, Honorable Speaker and the members, as you deliberate on that issue, we sound that caution that whatever is established today will have an implication on future impeachment processes that will be brought before this House. On the second ground of the PU, Honorable Speaker, counsel for the governor have referred to affidavits by the clerk of the Assembly and affidavits by the AP commander, Isiolo County. And all these affidavits, Honorable Speaker, have been referred to persuade you that there was no sitting by the Assembly on the 26th of June 2025 when the impeachment motion was approved by the County Assembly. The question that arises, Honorable Speaker, is whether the contents of those affidavits can established, whether the contents of those affidavits are to be believed without testing the evidence of those witnesses under oath. So the way I see it, Honorable Speaker, is that the governor is asking for a full trial. By making a reference to those affidavits, it must be taken that the governor concedes that that PO is not a pure point of law, is not based on a pure point of law that can be canvassed by counsel without reference to affidavits by witnesses. The reason we file affidavits before you, Honorable Speaker, is to give advance notice to the other party so that the other party can prepare on how to test the truthfulness, the credibility, and the veracity of those witnesses when they take the stand to give evidence before this House. So, Honorable Speaker, the contents of those affidavits, the depositions that are contained in those affidavits would have to be tested by way of cross-examination of the witnesses for this Honorable House to make a conclusion on that question as to whether there was a sitting. The same goes for the answer that is impugned by the clerk of the County Assembly on oath. With regard to the question of further on that question of the alleged forgery of the answer, all the counsel for the governor has done is to make reference to an affidavit by a witness. Counsel was submitting on what is supposed to be a preliminary point of law. It is no longer a preliminary point of law, Honorable Speaker, if counsel does not restrict himself and now, takes the posture of the witness and testifies on behalf of a witness on what they have deponed under oath in an affidavit. At the opportune time, Honorable Speaker, we will be praying to cross-examine those witnesses in order to establish the truth. The further question that arises, Honorable Speaker, as I conclude, is the clerk of the Assembly under the County Assembly Services Act is required to render expert, non-partisan advice to the Speaker and to the House on procedural matters and all other matters that are before the House. We will be craving for an opportunity to cross-examine the clerk on all the issues that Council has alluded to in trying to persuade you, Honorable Speaker, and the House that you dispose of the issue of whether there was a sitting and the issue whether there was forgery of the answered at this preliminary trial. A mini trial that the governor requests for, a trial within a trial, is not necessary, Honorable Speaker, if the issues that are to be canvassed during that mini trial can be established in the full trial. Or that the issues of the sitting of the Assembly, the issues of the alleged fraud, the alleged forgery, are matters that belong to the full trial. It is for the governor to prove that indeed there was forgery, because he's the one who alleges there was forgery of the answered report and that there was no sitting. It is for the governor to prove through evidence that is going to be tested by way of cross-examination at the trial. Therefore, Honorable Speaker, reducing that issue, and it's a very germane issue, the issue of the sitting and the alleged forgery, to a matter that can be handled at this stage without leading evidence, is not only inappropriate, but against the best interest of justice, because the County Assembly will not have the opportunity to cross-examine the witnesses that are being called and whose affidavits have been referenced to by the Governor's Council in making that preliminary point. In conclusion, Honorable Speaker, it is only after a lengthy and a drawn-out hearing in the main trial that all these issues that are couched as preliminary objections can be sufficiently addressed. Honorable Speaker, I'll say one last thing on that issue of the court order before I cede a few minutes to my colleague, Mr. Muriuki. Honorable Speaker, the issue of the court order that is the governor has alluded to is not to be looked at just as a standalone issue or as it is essentially, Honorable Speaker, an attack on the jurisdiction of this Honorable House to hear the impeachment motion that this House is seized of. The question, as I said before, is if a court whose jurisdiction is challenged, because in fact, Honorable Speaker, I was in those proceedings and the jurisdiction of the court was challenged. The court has not rendered a decision on a preliminary objection that was filed, but the court proceeded to grant the orders that were granted. Can a court whose jurisdiction is challenged and which court, the apex court in the Republic, together with the Court of Appeal, have held that our court is bereft of jurisdiction, take away the jurisdiction of this House, which is constitutional in nature, the jurisdiction of this House to oversight county assemblies is constitutional in nature. Can a court acting in excess of jurisdiction take away the constitutional mandate of this House? As Mr. Nyamodi quoted just before he took the stand, Honorable Speaker, the decision in Mark 4 on the validity of that court order comes into play. Because, Honorable Speaker, there would be no there is no need for that court order to be set aside. The moment that court order was given by a court that has disregarded binding precedents from the Supreme Court, from the Court of Appeal, and acted in excess of jurisdiction, that order is a nullity in law. So much as the court order says that the proceedings before the Assembly were a nullity in law, the court order itself is a nullity in law. There is no further order of court that is required to set aside that order, because that order itself is a nullity in law. It cannot stand. Therefore, Honorable Speaker and the Senators, I urge you, as I conclude, not to cede to the request, not to accede to the request by the Governor's lawyers to take away the jurisdiction of this Honorable House on this important question that is before you for determination. I will cede the remaining minutes to my colleague, Mr. Mzalendo.
Honorable Speaker, esteemed members of this House, my name is Eric Murioki. I am privileged to appear before you once again. I represent the County Assembly of Isiolo. Honorable Speaker, esteemed members, to continue with our submissions where my colleague has left off, the question that should seize this House, and Honorable Speaker, when you go to make your determination, is this. On a balance of conveniences, what ought to happen? We submit that this House ought to proceed with these proceedings because, as has been held in numerous court decisions, the Governor will have the opportunity to challenge these proceedings in court. However, neither the court nor this House can freeze the statutory and constitutional timelines that are set for impeachment proceedings. So, Honorable Speaker, allowing the PO in the way that the Governor's team asks this House to do would irreparably prejudice the Assembly, because there is a chance for the Governor to challenge these proceedings, but there is no chance for the Assembly to reinstate or to pause this process and then come back. The proper time to question the validity of impeachment proceedings, as has been ably submitted by my senior Nyamodi, is after the process is complete. And Honorable Speaker and members, this is what the court held in the case of Kawira Mwangaza versus the County Assembly of Meru. Honorable Speaker, this position was also buttressed or had earlier been held in the Mate, Justice Kariuki Mate matter. Honorable Speaker, allow me to read an excerpt from the decision of the Court of Appeal, that is Mwangaza versus County Assembly of Meru and another, 2023 KECA. We observe that the applicant's right to be heard and to defend herself from the allegations made against her in the impeachment debate at the County Assembly of Meru provided under the standing orders of the County Assembly. If she is impeached, and emphasis on this part, Honorable Speaker, she will have another opportunity to present her case before the Senate during the hearing of the impeachment motion. Further emphasis here, Honorable Speaker, even after the Senate makes its decision, the applicant still has the avenue of petitioning the court for an appropriate relief if the decisions were to go against her. We are therefore of the considered view that the applicant's right to be heard will not be circumscribed. Enough said, this court lacks jurisdiction to consider the application before it for the reasons stated in the ruling. That is the Court of Appeal, Honorable Senators speaking. The second question that this House and Mr. Speaker should ponder is, where is the public interest in this matter? In this matter of the PO. This is an important question. The impeachment process has commenced. The Supreme Court and the Court of Appeal have, in very clear and no uncertain terms, forbidden. They have forbidden lower courts from granting the kind of orders that the governor has brought here today, saying that he wishes to rely on to scuttle these proceedings. And, honorable senators, even where such orders are issued, what does the Supreme Court say? It says that should those orders be issued in error, then the assembly, the county assembly, is entitled to not immediately comply with those orders. Honorable Speaker, these are not my words. These are the words of the Supreme Court itself in the Mati decision. Paragraph 95 of that decision, and it is found in page 8 of our submissions, where the Supreme Court says, it is our understanding that the exceptional circumstances of this case, with a complex scenario of justiciabilities from contrasted standpoints, would lend justification to the non-effectuation of contempt orders at the beginning, and consequently, we would accommodate the reality of their not having been immediate compliance as would otherwise be required. The Supreme Court is recognizing that sometimes court orders are issued in error, and where the effect of those orders is to encumber a House of Parliament, a legislative house, from performing its duties, the Supreme Court is accommodating the reality that those orders do not have to be immediately complied with. Your honorable senators, on this basis, we therefore submit that it is in the public interest that this House dismisses this PO and proceeds to hearing, bearing in mind what the Supreme Court has said, what the Court of Appeal has said. Honorable senators, another issue I want to touch on is the issue of forgery that has been alleged in the governor's preliminary objection. And the only submission I will add to what my colleagues have said on that issue.
Counsel for the County Assembly.
Yes.
Just take your seat. I've got a communication to make. Now, honorable senators, ladies and gentlemen, the time now is 1 p.m. And in terms of our program, we are set out in the order paper. We are set to adjourn at this time. I note, however, that the County Assembly still has 10 minutes of their time. I therefore wish to invoke Standing Order 34-2 and 2A of the Standing Orders, which permit the Speaker, for the convenience of the Senate, to direct later interruption of the business for a period of not more than 15 minutes. I therefore direct that the County Assembly may utilize its remaining 10 minutes so that the Senate shall adjourn at 1:10 p.m. or such earlier time as the County Assembly concludes its submissions. The Senate then will resume sitting at 2:30 p.m. when the Governor's Council will have its 10 minutes to respond before the Senate proceeds to make a determination on the preliminary objection. It is so directed. Council, you may proceed to utilize your 10 minutes.
Thank you, Mr. Speaker, sir. As I was submitting, honorable senators, is that my colleagues have indeed said, and I agree completely, that forgery must be specifically pleaded and proven. The mere word of the Governor's Council on this pulpit cannot be taken as evidence of forgery. Indeed, in a decision of the Court of Appeal, Jennifer Nyambura Kamau versus Humphrey Bakanandi, the court held that it is also a settled law that fraudulent conduct must be distinctly alleged and distinctly proved. It is not allowable to leave fraud to be inferred from the facts. An allegation of forgery is an issue of fraudulent conduct. Honorable senators, you have been told that it is a preliminary issue whether there was a sitting and whether from that sitting threshold for impeachment was reached. Honorable senators, this issue can only be determined after a conclusive hearing of these proceedings. The Governor's Council has stated that they will rely on the affidavit of the clerk, who is an employee of the County Assembly, to tell you that there was no sitting. Honorable senators, as a matter of fair hearing, we must then be allowed to test the veracity of those averments by the clerk under oath through cross-examination. And for that reason, honorable senators, this issue cannot form the basis of a PO. Honorable senators, from the locus classicus on POs of Mukisa Biscuits, as was again affirmed in the decision that we have quoted in our submissions of Ali Hassan Joe and another versus Suleiman Said Shaban, for a PO to succeed, it must be a pure point of law which is argued on the assumption that all the facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is sought is the exercise of judicial discretion. And I would perhaps just amend that to also include quasi-judicial discretion, because this House now sits as a quasi-judicial body. So, honorable senators, that issue of whether there was a sitting is at length canvassed in both the County Assembly's documents and the Governor's responses. And for that reason, it therefore cannot form part of a preliminary objection. We shall be, of course, adducing evidence to show that there were sittings of the Assembly on those 2 dates, even though there were attempts to scuttle those sittings. Honorable senators, as I conclude my submissions, we shall lead evidence at the opportune time to show that there was vandalism at the offices of the County Assembly and that the said vandalism was orchestrated by the Governor or at his direction. That is the evidence that we shall bring here. We shall also lead evidence, honorable senators, to show that there has been a pattern of attempts to scuttle these impeachment proceedings right from the start, and these attempts were made by the Governor. We shall adduce evidence to show that the Governor took every possible step, whether legal or otherwise, to try and stop and scuttle these impeachment proceedings. For these reasons, Honorable Speaker and Honorable Members, we submit that it is necessary and this House ought to rule that that PO is untenable and that we proceed with hearing of the full case. My colleague will finalize our submissions. Thank you.
Honorable Speaker and members of the Senate, I'll just take a few minutes just to conclude our remarks on behalf of the County Assembly. Honorable Speaker, I would just like to highlight the two-faced approach to the contest raised by the governor. On the one hand, the governor is saying that there was no motion, no resolution passed that is capable of coming before the Senate.
Counsel, for the sake of the Hansard, kindly state your name.
Honorable Speaker, my name is Paulo. Honorable Speaker, before I proceed,